Schedules of the Constitution, 9th, 10th, and Anti-Defection Law Part 1. The original Constitution only carried 8 schedules, while we have 12 schedules after subsequent additions as seen below. Schedule 9, First Constitution Amendment Act 1951. Schedule 10, 52nd Constitution Amendment Act 1985. Schedule 11th, 73rd Constitution Amendment Act 1992. Schedule 12, 74th Constitution Amendment Act 1992. Let's talk about Schedule 9, added by PM Nehru through First Amendment Act and will be dealt in detail in the Fundamental Rights section. Okay. Schedule 10. Schedule 10 was added before in a different form and removed before being replaced by provisions relating to the anti-defection. In the earlier version, it contained provisions detailing the relationship of Sikkim as an associate with the Indian Union. Associate state means state or territory partly controlled by a stronger state but autonomous in internal affairs. Okay, so this acts as a protectorate state. Sikkim was added as an associate state through the 35th Constitution Amendment Act 1974 through insertion of Article 2A and Schedule 10, while were subsequently repealed after it became a full-fledged state in 36th Constitution Amendment Act 1975. The present schedule deals with anti-defection and is attached to Article 102 Clause 2 and 191 Clause 2. It was added through 52nd Constitution Amendment 1985. Anti-defection doesn't apply to general party workers but to those members who have been elected to the legislature based on the party's ticket. The Schedule 10 in the Constitution only deals with defection arising at two levels: Union and states. The panchayats and the urban local bodies are excluded from it, and it's upon the state legislature to include the provision in the state local body legislation. Why such legislation was needed? Breach of trust. Resigning the party with which the candidate has been elected leads to breach of trust of the public, who may have voted for the candidate based on the party affiliation or the leader of the party. Instability. Mass defection from a party leads to instability of the government as it reduces the party's majority in the legislature, and in extreme cases even the government can fall. Political corruption. Prevalence of money power in politics has led to the swinging of loyalties, and hence it amounts to political corruption. Political parties. Parties deploy a lot of resources in terms of canvassing, money, manpower to get the candidate elected. Hence defection tantamounts to treating the party in a casual entity. Tantamounts means equivalent. So defection equivalent to treating party in a casual entity. Casual entity means working on a temporary as required. In late 1960, defection was becoming rampant, and thus committee under Y.B. Chavan was appointed. Rampant means occurring or increasing in an unrestrained way, not subjected to any limitation means. It suggested the moment a legislator defects from the party and joins another party, he should be disqualified and fresh election must be held, but stopped short of recommending disqualification as a result of defection. The first attempt at curbing the practice was in 1973 through the 32nd Constitution Amendment Bill, which did not pass. The second was in 1979 through 48th Constitution Amendment Bill, which also did not pass. Eventually, anti-defection law came into being in Rajiv Gandhi's premiership through 52nd Constitution Amendment Act 1985. Provision of 10th Schedule. Resignation from political party leads to seat being vacant. The provision was present in the original law, but along with defectors, if 1/3 split, it would be deemed a legal split. This has been done away with now. Defying a party whip, if not condoned within 15 days. Condone means overlook, give excuse. Independent members. If they join a party, but they can support government from outside and even become ministers if the political party is decided as such. Nominated member. If the person who is being nominated is already a member of party, then if he defects, the anti-defection law will apply him too. If a nominated member is not a member of party, he has two options, namely, he can join a party within 6 months from the date of his nomination. Second, post the 6-month limit, if he joins a political party, anti-defection law will come into play. Exceptions. Speaker, Deputy Speaker of Lok Sabha and Legislative Assembly, Chairman and Deputy Chairman of Legislative Assembly and Deputy Chairman of Rajya Sabha are exempted. There is no such provision for Vice President, Chairperson of Rajya Sabha, since he is not a member of the House, so his defection does not arise. A Speaker or Deputy Speaker is allowed to resign from the party but is not allowed to rejoin the political party during his tenure as Speaker, and once her tenure ends, he can rejoin only his parent political party from which he resigned. After the 91st Constitution Amendment Act 2003, some changes were made in the anti-defection law and some changes in the Constitution too were added to further cement the effectiveness of it. The 1/3 split legal rule was repealed. The party with 2/3 majority resolution passed can merge with the other party. The members who do not support the resolution will not be treated as defectors and can continue as separate group. Changes in Constitution. An alarming concern arising from the prospect of becoming a minister was curbed by limiting a cap on ministers in Lok Sabha and assemblies. Article 75 1A, Article 164 1A. Article 75 1B states that any member who has defected cannot be appointed minister again by the executive for the remaining term of his office unless he gets elected to the House again. Article 361B. Any disqualified member shall also be disqualified to hold any remunerative political post commencing from the date of his disqualification till the date of election of the House. Issues with anti-defection law. Power to decide on the defection. If a case of defection happens, any member of the House can file a petition to the Speaker to take action under anti-defection law (ADL), and if the Speaker himself undergoes defection, the petition is supposed to be filed with the Secretary General of the House. And decision regarding anti-defection law petition against Speaker would be taken by such a person of the House specifically elected for the purpose. Since usually the Speaker holds the membership of a political party, any decision made by him can be seen with doubtful lens regarding the fairness of the process, since justice must not only be done but also needs to be seen to be done. Thus, the apex court in Quijotto Holahan case in 1992 said that there is no wrong in the case being decided by the Speaker, but there will be a provision for judicial review, since the Speaker acts as a quasi-judicial capacity exercising judicial functions, and the highest judicial court is Supreme Court, hence judicial review can be done. The adjudication process may also lead to errors due to deficient legal acumen, skill, etc. In one recent observation, the Supreme Court remarked that the role of Speaker as adjudicator in defection cases could be divested from him and hand over to body tribunal consisting of retired judges. Article 102 mentioning the grounds of disqualification including the defection provision. These disqualification provision excluding the defections once are decided over by the President of India according to the advice of Election Commission of India. Similar provisions for state legislature in Article 192. Article 103. Decision on question as to disqualifiers of members. 1. If any question arises as to whether a member of either House of Parliament has become subject to any of the disqualification mentioned in clause 1 of Article 102, the question shall be referred for the decision of President and his decision shall be final. 2. Before giving any such decision, the President shall obtain the opinion of the Election Commission and shall act according to such opinion. Whip gagging. The provision of whip suppresses genuine dissent. It does not allow to faithfully represent constituents. It does not allow following one's own conscience. It also reverses the paradigm of accountability. The anti-defection law reverses the paradigm of accountability between the executive and legislature. Paradigm means a standard or typical example, a way of looking at something. While the executive is supposed to draft legislation and convince legislators to vote for it, and hence the accountability lies on the executive and anti-defection law, the reverse happens, where due to an issuance of whip, our legislator has to vote for the legislation. Due to an issuance of whip, our legislator has to vote for the legislation. Even with the opposition, the ruling dispensation need not convince everybody, but has to convince opposition party leader to issue a whip and thus make them toe the line. Toe the line means accept the authority, policies or principles of a particular group, especially unwillingly. Thus it reduces debate culture in parliament and even genuine dissent. Why is parliamentarians' contribution less to parliamentary debate? Lack of policy awareness, governance issue, nature of technical issues, criminalization of politics, size of the houses too large while the number of sitting days has come down, increasing disruption of house during functioning. Plus a large number of discussion has been delegated to parliamentary committees. Due to anti-defection law, members cannot oppose the party stand in the parliament due to party's whip. The courts have given some leeway with regard to ADL. Whip should be applicable on vote of confidence, no confidence or major policy issue on which the party wants to polls. New trends in instability of government. Should ADL also include coalition formation, or in the absence of pre-poll coalition, should post-pre-poll coalition be allowed? Thus, instability can be caused in these situations too. Experts have suggested that pre-poll coalition should be covered by anti-defection law, and if there is any anti-defection, the party defection in bulk shall be disqualified.